Today's topic is about duty of care and breach of duty. We will have a look at an example essay question. This kind of essay questions I've seen many times in different tort law examinations all around British universities, and I believe that you should be able to answer this question because it is very likely that this kind of question comes up on an exam or comes as a coursework question if you have an upcoming tort law assignment. The duty of care in medical professions is no longer an established category where duty of care automatically applies. Critically discuss. First of all, I suggest that you plan your essay. Every essay, no matter what it is about, whether it's tort law, criminal law, contract law, it should be started with an introduction. Introduction should be around 10% of your essay. It should not be more than that. And the body paragraphs is where you elaborate the details and where you provide arguments for and against. It should be 80% of the essay in total. And finally, the essay should have the conclusion. Conclusion should be about 10% of the essay in total. Now, let's have a look at the contents of the introduction. I believe that for the introduction, for the purposes of answering the essay question, you should have first the definition of negligence. Secondly, definition of duty of care. You should explain what is a duty of care, citing relevant authorities. Cite the authority where duty of care in medical professions was established, because this essay question specifically asks you about medical professions. Introduce the issue at hand. Recent cases have demonstrated that duty of care is no longer established automatically in cases involving doctor-patient relationship. This is the case of Darnley versus Croydon Health Services NHS Trust. This case is a recent case. The Supreme Court decision in this case was delivered in 2018, which overturned the decision in Court of Appeal that was delivered in 2017. Therefore, it is very important that you analyze and compare earlier authorities with the latest authorities. But for the purposes of the introduction, only thing you do is just explain everything as I have recommended. Explain negligence. Negligence is the breach of the duty of care owed by the defendant to the claimant, which results in damage to the claimant that is not too remote. Therefore, the four requirements of negligence are duty of care, breach of duty, causation, and remoteness. Duty of care, according to Lord Atkin in Donoghue and Stevenson, proximity of neighborhood is a relationship that gives rise to a duty to take reasonable steps to protect the other party from harm. Therefore, there should be a sufficiently proximate relationship. This duty of care test was changed multiple times, and the latest test on duty of care is the one set out in Robinson. Originally, it's a Caparo test, but the third link of the Caparo test was reformed in the case of Robinson. Caparo duty of care test, as amended by Robinson, is the following. Firstly, it should be established that the reasonably foreseeable harm, therefore the defendant, this harm that claimant suffered should have been reasonably foreseeable. Secondly, sufficiently proximate relationship between the claimant and the defendant. Thirdly, established duty situation in line with previous authorities. Therefore, the situation that we're dealing with in this specific case should have been an established duty scenario according to previous line of authorities. In this case, we're talking about medical professions, so our focus has to be on medical cases that involves doctor-patient relationship. Doctor-patient relationship used to be an established duty scenario where duty of care is almost automatically assumed. You don't need to talk about it much in the introduction, but you do have to mention few things just to explain the issue at hand and set the scene for the arguments to come in the body paragraphs. Rowe versus Minister of Health is one of the earliest cases for doctor-patient relationship. Here, the hospital was liable for negligent act of their employees despite vicarious liability. Duty of care was established because doctor-patient relationship is an established duty scenario. So it was almost automatically assumed that duty of care existed because the claimant was the patient suing the hospital. Most of the judgment was concentrated on whether or not the standard of care here was breached, rather than if the duty of care existed. Most of the judgment was dedicated to the discussion of standard of care, as I explained, and if the doctor's conduct fell below the standard expected. However, we see a shift in approach in the case of Darnley versus Croydon Health Services. The majority judgment was concentrated in this case on duty of care element instead of breach of duty. This statement at the end of the introduction is very important. This is where you announce your plan of what you're going to argue in your essay. For example, in this case, it can be something like this. The present essay shall critically analyze if the duty of care in medical professions is no longer an established category where duty of care automatically applies. This is setting the scene for the arguments to come. This is explaining what you're going to argue in your essay. After the thesis statement, you need body paragraphs. This is where the arguments come. You have already mentioned at this point, you should have already mentioned a couple of cases in the introduction, but very briefly, just to introduce the issue at hand. Whereas in the body paragraphs, you have to elaborate the details and make an argument. It's not about how many cases you mention, but it's about the quality of your arguments. So you may have 2 or 3 cases for arguments for and against, but you may still get a higher grade than someone who had 10 cases, because it's not about the quantity, it's about the quality of your arguments. So make sure that whatever case you mention, you provide analysis and you make an argument or referring back to the question asked. 2 parts of the argument here. There are 2 sides of the argument that you need to argue. Provide supporting evidence, authorities, journal articles, etc. Doctor-patient relationship is still an established category of duty of care. So this is one part of the argument. You need cases and authorities and peer-reviewed journal articles to support this. And secondly, doctor-patient relationship is no longer an established category of duty of care. So this is for and against, basically. Arguments for proving that doctor-patient relationship is still an established duty of care. Demonstrate case law that shows duty of care automatically applies to doctor-patient relationship. This was, for example, Rowe versus Minister of Health, or Ball versus Devon Area Health Authority. Both cases are early stage cases where the court argued that duty of care existed. There was very little discussion about it because it was obvious. And both cases concentrated on whether or not the breach took place here, considering the standard of care and if the medical professional in those cases fell below the standard expected. Argument overview. This is the kind of arguments you would be expected to make. In the introduction, you should have briefly mentioned the relevant issues and cases, but body paragraphs should elaborate, give details and arguments. This side of the argument should be based on the grounds that in earlier cases, the court focused on standard of care and breach element instead of establishing duty of care in medical negligence cases. James Goodcamp is a good article. He wrote an article, a peer-reviewed journal article about duty element being a disappearing element in negligence because established duty scenarios are no longer treated that way. I believe that you should have a look at his article and mention his commentary, his critical analysis to make arguments for and against this topic. Arguments against. The case of Darnley versus Croydon Health Services, this has to be the key authority here. There is a Court of Appeal judgment and there's a Supreme Court judgment reaching contrasting outcomes. In the Court of Appeal, it was argued that hospital did not owe duty of care to the patient. That was a big judgment because it was very important, and that's actually what was analyzed by the article, James Gutkamp article, Breach of Duty, a disappearing element of the action in negligence. This article talks about the Court of Appeal judgment of Darnley, where it was argued that hospital did not owe a duty of care to the patient. Normally, hospital always owes duty of care to the patient, so this was different in this case. The facts of the case is basically a patient went to the hospital in an emergency room and he was feeling ill and he was misinformed about the waiting times in the emergency room. He was told, after he said what his condition, his issue, why he was visiting the emergency room, he was told that he had to wait about 4 to 5 hours in the emergency room to get the treatment, to get seen by the doctor. And he didn't want to wait 4 to 5 hours. And he left. But in reality, he should have been seen in 20 minutes. So he was misinformed about the waiting time. That then resulted in a worse outcome. So he was suing that if he had seen in time, the outcome would have been not this bad. So he suffered harm because he did not receive the treatment in time. The contrasting argument here was that, well, it was his fault that he left the hospital, but he was arguing that it was the hospital's fault because they have a duty of care to inform their patients in the emergency room about the correct waiting times. The Court of Appeal said that in this case, hospital did not owe a duty of care, where the Supreme Court overturned the decision and said that hospital had to take reasonable care to not provide misinformation to the patients. Support your arguments with case law, peer-reviewed journal articles, and law commission reports for reform proposals. But the reform proposals should not be necessary for timed exams. So if you have, for example, just 1 hour to write an answer, most likely they do not expect you to write this much detail. But if you have a comprehensive coursework to write on this topic, I do suggest that you provide some reform proposals, because critical analysis should logically be accompanied with reform proposals, because when you provide critical analysis, you are exposing the problems of the law at hand, and you also should provide a solution, which is the reform proposal. Where do you find reform proposals? You can find them in journal article or law commission reports. It is recommended that you have your original arguments as well, rather than just take everything from journal articles and law commission reports. However, your arguments, your original opinion arguments, shall be reasoned and supported with authorities or academic commentary. And finally, I just wanted to give you a couple of thoughts about why the courts changed their approach from earlier cases to Darnley, why Darnley was decided in a different manner in the Court of Appeal. I believe that firstly, it's about floodgates of liability. If duty of care was automatically assumed like it was before, in the modern society that has become very litigious, it would result in floodgates of liability. More and more people would be bringing actions against hospitals if the duty of care was automatically assumed. So that is why we have the test of Caparo and Robinson to apply in every scenario. Even historically, doctor-patient relationship meant that automatically there was duty of care. It's no longer the case because of modern society becoming too litigious and to control the floodgates of liability. In the conclusion, you should sum up your main arguments and answer the question asked. The question was, is doctor-patient relationship still an established category of duty, where duty of care is automatically applied? You have already presented by this point arguments for and against, reasoned arguments from case law, journal articles, your original arguments as well. So you have explored both sides of the topic, both sides of the legal issue, and now you should answer the question asked. After discussing both sides of the issue, which side do you think is more convincing and why? Do you think that doctor-patient relationship is still an established category or not? I believe that yes, after analyzing all the case law and journal articles, I believe that yes, it is still an established category of duty of care, but the test has to still apply. Most of the times it will be positive, because as we saw in the case of Darnley, Supreme Court overturned the position of the Court of Appeal and said that the hospital did owe a duty of care to the patient. So it will be very exceptional case if the court considers that the hospital doesn't owe a duty of care to patient. That must be a really, really exceptional case. So normally, yes, it's still an established category of duty of care, but it is not automatically assumed. Duty of care test still applies. Finally, just a couple of minutes, I'd like to talk about SimpleStudying and how we can help you with your assessments. Firstly, I suggest that you have a look at our SimpleStudy materials in Tort Law. We have simple notes on point that gives you exactly what you need to get a high grade. You can watch our tutorial videos. The tutorial videos are about many different areas of tort law, similar to this class. Use our quizzes and flashcards to test your knowledge. And you can also have a look at our model essays and exam tips to understand better how you should answer problem and essay questions. Additionally, we have tutoring sessions tailored to every student's needs. We help you learn correctly how to get high grades, practice legal writing, get some guidelines on exam and courseworks. We have already helped thousands of law students get a high grade. We have over 17,000 subscribers from most of the UK universities. And 90% of our regular users will get at least 6 hours of tutoring, and our study materials get a first class, as you can see on our reviews. If you would like to be our next student to get first class, please join SimpleStudying now. Thank you very much for your attention.